I can give a response at that time.
Okay, okay. Um, so I think because Morgan, are their questions going to go directly into the chat where everyone can see, or will it come just to Miss Catrella see?
I see that we have the Q&A up on the top. I don't think we have the chat function, do we, with the panel? I don't think with the panel we're able to have the chat function, so it would probably go into this Q&A spot at the top.
Okay, will you be able to see that to where you type
I
the question?
should. I should be able to.
Okay, and I'll keep an eye as well. I don't see where that is yet, but
Yeah, we could probably just do Q&A at the end because we'll be able to still see them.
okay, okay. So I'll tell them if they have a pressing question where they're not sure if they're going to remember at the end, go ahead and
Okay,
ask.
yeah.
If they raise their hand, I think they can raise their hand or even ask in the chat and we'll try to answer it. Or if they think of a question, put it in the chat and then we can go through and answer it at the end. Would that be better?
Yeah, I can do
Yeah.
it that way as well.
Okay.
Yeah.
Okay.
That's good.
All right. We'll do that. Okay.
So excited. Thank you so much, Miss Nash.
It's no problem. No problem.
All right. Let's see. Let me grab everything and put it up here so that we're ready. Let me see. Nope, wrong thing.
We are
All
right
right.
on time, Roz, because the kids are not home yet. It's about to
Okay.
get loud. Let's
All
get this
right. Let me
over.
go and find all of our stuff. Okay. Let's put my eyes on. All right. Are you all logged in yet? Um, okay. Did you log on the training one or just the regular one? Okay. Okay. Are you all able to see my screen?
Yes.
Okay. Thank you, everyone who is joining. We're going to get started. If we'll just give everyone about 3 more minutes and we'll get started. Thank you so much for those who have been here promptly on time. Um, we appreciate you, and we'll start shortly. So we're going to go ahead and get started. It is 8 after, and I want to thank our guest speaker and definitely want to be respectful of her time. So we're going to go ahead and get started. First of all, just want to say good evening to everyone and welcome everyone for being here this evening. Thank you for coming for tonight's virtual Know Your Rights training series, where we're going to focus on empowering justice impacted people with knowledge and tools and resources that are needed to advocate for themselves and also in the community. So, we are truly honored to have you join us tonight for this important conversation. And just so that you can understand the judicial process, which will be led from no other than Miss Attorney Cottrell Nash, who we will introduce shortly. But before we begin, I just want to take a moment to share with you who we are and why this work matters to us. So, my name is Rosalind Calhoun, and I am the Reentry and Partnership Coordinator here at BARD Business. BARD Business is a Black-led women organization. We are deeply committed to healing, resourcing, and building power for justice impacted communities, their families, and we just want to make sure that we are here. We are doing this work to heal, to resource, and build power. We work in three buckets, which are policy advocacy, organizing, and civic engagement. And our vision is big and our vision is bold. We envision a world where justice impacted people can live, earn, build collective power, and grow economically, where we are free from discrimination. And we know that our vision can come to reality, but we just have to do that work without just imagining the change, but we must build it. We must build it. So that's why we actively work to change these harmful policies and transform broken institutions that are led by strategic electoral efforts. And we want to make sure that we not only hold it, but we grow it. So our work is rooted in the belief of justice impacted people who don't just need saving. We need systems that can stop the punishment that is happening. We need systems that will stop punishing and start investing. We need the investing back in justice impacted people so that we can start dismantling some of the systematic barriers that have kept too many of us locked out of opportunities. So we're creating new pathways and pathways that lead to equity, healing, ownership, and also leadership. And we are proud here at BARD Business to be led by our brilliant director and founder, Miss Bridget Simpson. And we are also led by our most phenomenal and brilliant co-founder, Denise Rubin. These two women have poured their hearts, their wisdom, and their lived experience into this work. So we certainly applaud them. We shared our 5-year anniversary on last, what was it, June 25th. So we had a marvelous, marvelous time. Thank you for those who have come out and shared with us. We certainly enjoyed you, and we had a time. As they say, a time was had. So tonight, whether this is your first time with us or you've been walking with us for some time, we thank you. We appreciate you for showing up, not just for yourself, but for your family and your community. So we're going to dive into this evening's session. And I just want to let you know there's going to be a lot of information given tonight. If you have questions, if you can save your questions to the end, that would be absolutely amazing. If it's something that's just pressing, and you just got to get it off, just do a hand raise or put it in the chat and we'll make sure that we get to you. But without further ado, I'm going to pass it on to Miss Morgan so that she can introduce our phenomenal speaker for tonight. So let's get to it.
Thank you so much, Roz. That was absolutely phenomenal. Love it so much. So I'm super excited. I'm going to go ahead and give Miss Nash's background and my own 2 cents. But Miss Cottrell Nash is a native of Biloxi, Mississippi, and daughter of a military veteran. She earned her degrees from the University of Southern Mississippi and Mississippi College School of Law. She became licensed in both Mississippi and Georgia and became the first attorney in her family. She began her career as an assistant public defender for the Augusta Judicial Circuit, representing clients in misdemeanor and felony cases across multiple counties. Her performance and her leadership roles, including felony trial team leader and co-supervisor of the state court division. As founder of Nash Law LLC, Ms. Nash has secured hundreds of favorable outcomes, including dismissals, reductions, and acquittals, earning recognition as a top 40 under 40, rising star, super lawyer, and lawyer of distinction. She is known for her legal precision, tenacity, and commitment to justice. She is a trusted ally in criminal, family, and juvenile law matters. And now I just want to go off paper and just say, honestly, I've had the pleasure of meeting Ms. Nash at multiple community events. She is a shero in the community here, and she really does care. And so I am just so honored that she's on the call, because you guys are not learning you're learning from the best, okay? So without further ado, thank you so much, Ms. Nash.
Whoa, that introduction. I feel like I need to write you a check. I want to thank Bar Business as well as Ms. Calhoun and Ms. Boyd for inviting me to be here this evening with all of you. It is definitely my honor to be here and to be able to speak to you about criminal law. It's one of my passion areas. And so I do want to encourage you that, as it's already been stated, if questions come to mind, write them down, and let's see if we can flesh it out at the end of the presentation. And so we can just jump into the first slide. I'm going to tell you all, as we're getting to our first slide on just criminal law, I've been doing this for almost 16 years come November 4th. And I can tell you that one of the most rewarding things about criminal law is when you're able to really see a person who has had the misfortune of having to go through our criminal law system but come out victorious. And victory looks different for different people. Sometimes that victory is an acquittal. Sometimes it's a dismissal. Sometimes it's a reduction. Sometimes it's probation. Sometimes it's less time than what they were looking at in terms of mandatory versus a non-mandatory minimum type charge. And so there's a lot of things that I do want you all to consider. If you ever have contact with the system or you've been through the system, hopefully you won't have to go back through that process of going through the system as a repeat offender. So to those of you who don't have a whole lot of information about how does the criminal justice system work, there are stages. The first thing that happens typically is there's some type of crime. And then from there, officers do an investigation. They need probable cause for a warrant, an arrest warrant. That probable cause usually just means there's some evidence that a crime has occurred, and then there's been some reliable evidence, whether it's eyewitness accounts, video footage, whether it's something that can be established through a reliable paper trail that identifies a particular person known as a suspect, where a warrant is issued for that individual. That person is first arrested. Now, once a person is arrested on a criminal arrest warrant, the court has 48 to 72 hours to bring that individual before them to, number one, tell them what they're accused of doing. Essentially, that is established by reading the arrest warrant. In addition to that, the court has an obligation to tell you up front if you're eligible for bond. So while you're waiting for all of these processes to take place, unfortunately, what happens is you're booked into a jail. Anytime you're booked into a jail, you are fingerprinted, you are photographed, your personal information is documented. Oftentimes, I'm not sure what areas of the state some of you who are on this webinar are from or living in, but I can tell you here locally where I'm at, I'm in Augusta. We have local publications that publish anytime someone's arrested. Some of these publications are online. Some of these publications are dual, both digital and in paper, but it's public record when you're dealing with adults. And just for your awareness, in Georgia, an adult is 17 or older. So that's right, you could be a child at 17 and still in high school, maybe a junior or a senior, And the local newspaper, if you're arrested on any kind of charge, the local newspaper can gain access to your photograph. They can also gain access to the incident report that led to the arrest and a copy of the arrest warrant, and all that information can be published online or in print. So once you see a judge and the judge decides whether or not you're eligible for bond, if you are eligible for bond, you're going to need money or property. Unfortunately, what we find is that there are people who don't have those resources. So unfortunately, what this results in is a disproportionate number of people who may not be able to post bond even though they have bond. What happens when you're in jail? For long periods of time, you're not able to post bond. You might very well have a solid defense to the charge. If a prosecutor's office starts offering probation, sometimes you might find that person's going to accept that probation because that means they get out of jail and they don't have to put up anything or pay anything to get out of jail at that point. And as opposed to someone who is in a similar situation of being charged with the same thing, may have a solid defense, but they do have the money, or their family or their friends are able to pull their resources together to post that bond or that bail. But ultimately, the next step once you're arrested on an arrest warrant is bond. If bond is granted or if it's not granted, and you decide that you do want to fight the charge, you're going to start to receive court dates. At court, there are multiple reasons that you could be brought to court, and the regularity of how often you go to court is going to vary depending on what county you're in. It's going to vary on the caseload of the agency that's prosecuting the case. It's going to vary on the availability of witnesses depending on the type of court date. But I can tell you in the region where I'm practicing, if a person is charged with a felony, we'll start getting court dates. If we don't request them, the court is setting them 90 to 120 days out. There are some counties that are more rural where I've seen after they have a bond hearing, they may not get another court date for 6 months to a year, sometimes longer than that. So that can be very painful for somebody who might be incarcerated. But if that person's on bond, while that may not feel restrictive in the sense of, okay, I'm out of jail, I'm at home with my family, I'm moving about in the community, it can feel restrictive when you're trying to, for instance, gain employment. And when the background check happens, in your background, you see that there's an open case and an employer has questions about that, or a potential employer has questions about that. So the major court dates that you deal with when you're out on bond or you're in custody or in jail waiting for your court dates are going to be either a calendar call or docket call. That's where you're giving the court an update on the status of the case. Oftentimes, before then, there will be an arraignment. Arraignment is where you are telling the court you're not guilty or guilty of the charge. The next court date after you do like a docket call or a calendar call is going to be any kind of pretrial motion type hearing. So some counties have pretrial conferences. That's where you get everybody in the room. Everybody is the DA's office if it's a felony. If it's a misdemeanor, it's going to be the solicitor's office, or in some counties, it's still the DA's office. You're going to have the probation office present. You're going to have the judge present, and you're going to have the defense attorney and the person who's actually accused in the courtroom. And the objective is, I'm sorry, you all, I'm still at my office. The objective of that court date is to see if you can either achieve a resolution in the case. If so, it'll be resolved right then and there. If it's going to be a trial, to identify what are some of the issues with the case that you need a judge's input in. So a lot of times you may have evidentiary issues. I'm sure some of you have heard about your Fourth Amendment right to be free from unreasonable search and seizures, or your right to remain silent, or something called Miranda, which is based off of a United States Supreme Court case, where you're talking about the right to have an attorney and to be told that you have the right to have an attorney if a police officer has you in custody and also wants to subject you to questioning. You might find that there's a piece of evidence that was obtained, but it was obtained illegally, not just in violation of your rights, but just in general illegal. There are certain motions that you can file called a motion to suppress. And a motion to suppress is where you're challenging the constitutionality of that police officer getting whatever evidence they're trying to use against you. Or the officer took statements from you that are incriminating. And what I mean by incriminating is that those statements make it sound like you did something that violated the law, but they didn't tell you that you didn't have to make that statement. They didn't tell you that before they questioned you that you could have an attorney. In those instances, you would want to file a motion to suppress or have a hearing before the judge where the judge decides just on the evidence, was it obtained legally? Because if it was obtained illegally, then it should not be used against you. And if it cannot be used against you, then what happens is the court is supposed to suppress it. In other words, throw it out. And if it's thrown out, guess what? They don't have a case anymore because they cannot use that evidence against you. So that is the goal of a pretrial conference or a motions hearing before you even get to the step of a trial. So let's say that you do or you don't have a motions hearing, but if you do have a motions hearing, it goes in favor of the prosecutor. The next stage is going to be you're either going to trial. You have the option of two types of trials. There's a jury trial. If it's a jury trial, that means it's a trial amongst your peers. Your peers are people who live in the county in which you are indicted or accused in. So let's hypothetically say that you have a crime that you're accused of in Fulton County. The people who decide the case, if you go to trial, those people have to be residents. They have to live in Fulton County. If you do a jury trial on a misdemeanor, and a misdemeanor means it's punishable up to 12 months in the county jail and up to $1,000 fine. A misdemeanor typically is going to be like a traffic charge, like a speeding or a DUI. It's usually encompassing petty thefts like a shoplifting under $500, a theft by taking under $1,500. It also includes domestic violence offenses like simple battery, simple assault. There's also a misdemeanor version of terroristic threats, which is basically telling someone you're going to cause bodily injury to them. You don't do it, but you're accused of saying that you would. Those are examples of misdemeanors. If you opt to have a jury trial on a misdemeanor, that's 6 people from that county. If it's a felony means that that charge is punishable by 1 year or more in the penitentiary. Not to be confused with the county jail. The county jail is where someone goes when they're arrested on a warrant and they're waiting for trial. The penitentiary or prison is the Department of Corrections. That is an institution that is set up just for people who have been convicted of doing a crime or criminal wrongdoing. So anything 1 year or more is a felony under Georgia law. And so if you opt to have a jury trial on a felony, the jury is going to consist of 12 individuals. Now, let's say the person opts not to go to trial. Trials are risky. And the risk is that oftentimes when people go to a jury trial, if they are convicted of 1 or more offenses, though we're told that you are going to be treated just like everybody else if you opt to have a trial and you are convicted, oftentimes judges impose more severe sentences because from their point of view, there was no acceptance of responsibility. And so if they see that there's no acceptance of responsibility, which by virtue of going to trial, you're saying I'm not guilty of these offenses, the likelihood of confinement, the likelihood of more confinement than you would have received is significantly increased. And so that's where you get the idea of what is probation versus what is parole. So typically, probation means that you remain in the community, you're sleeping at home, you are able to go about your day to day life, but on a pretty consistent basis, you're meeting what an officer called a probation officer. And that person is monitoring to make sure whatever conditions the judge imposes in your case are being met. So if the judge says at the sentencing, hey, I need you to do random drug screens, well, the person to facilitate the drug screens is the probation officer. If the judge says, I want community service performed, well, the judge does not have the ability to see if you're doing community service or not. There's too many cases, and it's just not possible. So that's where the probation office fits in, to supervise and make sure that community service is being accomplished. If there's a fine, probation breaks down that fine into monthly installments like a credit card bill or any bill for that matter, and they make certifications to the judge that these conditions are being met. Parole is about the same in terms of the supervision. But the difference between parole and probation is parole means that a person, as part of their sentence, was ordered to the penitentiary or prison. And the Department of Pardons and Parole evaluated the case and determined that instead of keeping a person in prison, inside of an institution, this person, they believe, is a good candidate to be back in the community, but subject to parole supervision. So what happens is if a person is released onto parole, that person is going to be monitored much like a person on probation by an officer. And that officer is going to make sure that that person is staying out of trouble, that that person lives at a particular residence. They're going to make sure that whatever other conditions that the parole board set is being met, such as if that person's supposed to be gainfully employed, that probation officer is going to make sure that person is gainfully employed. If that person is supposed to stay away from certain areas, that parole officer is going to periodically check to make sure that person is not in that area. So just to again tell you the distinction between probation and parole, probation means you've been in the community the whole time. That is your sentence. Parole means you should be in prison, but you're given an opportunity of early release and you're monitored by parole. And it is very possible to be both on parole and probation. That happens from time to time when a person has overlapping sentences. So to just recap, if you're on probation or parole and there's a sentence, either you've pled guilty to the charge, B, you've accepted a sentence to the charge under first offender, conditional discharge, or C, you were convicted at a trial, meaning it's involuntary. You were found guilty by the jury. Now, I told you that there are two types of trials, the jury, but there's also something called bench. A bench trial is where the judge decides whether or not a person is guilty or not guilty of a charge or charges. Please understand that you could be before the most amazing judge in the world. I think having a bench trial is very risky, and it's just my personal opinion. It's risky because if your case involves police officers and issues of credibility, sometimes it is best to let lay people, jurors, make the call on who they believe. Because the reality is, whether consciously or subconsciously, judges see these officers all the time. It is very challenging for a judge to make the decision to not believe a police officer over a regular citizen who is under criminal charges. In those situations, judges tend to lean towards law enforcement because law enforcement takes an oath to do right by the community and to tell the truth and to follow the letter of the law. And so whether a judge does it consciously or subconsciously, that officer starts with heightened credibility as opposed to a lay person. So I find in my practice that the only time I would ever ask for a bench trial before a judge as opposed to a jury trial is if I have issues that aren't about credibility, it's about the law and the correct interpretation of the law. And so, with that, I say that if a person is charged with a criminal offense and they're choosing between what type of trial they want, I always say go with jury trial if we're dealing with emotions and right versus wrong. And if we're dealing with understanding the law, the letter of the law, and moving aside the emotional side of things and just focusing squarely on the law, I would say go with a bench trial. Now, after you go through the process of trial, sentence if you are convicted, or if you're acquitted, you're done. But if you're not acquitted, meaning you're not found not guilty, you've been convicted, whether it's through a trial process or through a guilty plea or a first offender or conditional discharge process, you've been sentenced. What happens once you're on that sentence and you're trying to matriculate back into the community? What essentially is happening is if you're trying to go to school, you're going to have to disclose. What I mean by that is what I've noticed with applications. Applications oftentimes don't just ask if you've ever been convicted. Oftentimes, applications are asking, have you ever been arrested? What happened in that circumstance? We want a certified copy of the incident report or a certified copy of the disposition. Disposition meaning what was the outcome of that. We want copies of, any witness statements. We want copies of your statement. So schools, employers, they're getting way more thorough in their inquiry about individuals' backgrounds. Whether the charge was dismissed, it was sealed, whether it was a conviction, maybe it was a conviction to something less, or it was just an outright conviction where you've served your time, you've paid your debt to society, and now you are trying to rebuild. Oftentimes, these entities are going to want to go into all of that. And so I'm going to just go through more of these slides. And as we go along, I'm going to add on more to what I'm talking about, but I really wanted to start with a comprehensive understanding of the process. So what's interesting in Georgia is when you talk about who's responsible for the whole situation of the accusation to the arrest, is that it may not always be a police officer that is involved in the prosecution. Now, what do I mean by that? So, what makes Georgia unique is that if an officer hears evidence of a crime, that officer has the discretion to say, well, I'm not going to issue a warrant, but what I'll do is I'll draft a police report, or I will give you direction to go to a particular court and you can apply for a criminal warrant against the person that you say victimized you. So let me give you an example. An example could be, let's say you have a cell phone and your cell phone is stolen. And your cell phone is worth like $1,600 because these days cell phones are like computers. And let's say that you call the police, you notify them your phone has been stolen. You did Find My Phone. You discovered where your phone is at. You did some reverse looking on Google, or you put your Inspector Gadget hat on and you discover where your phone is located. You found an address. You were able to find out the name of the person that owns that particular address or lives at that particular address. You staked it out. You figured out who has your phone because you saw it in their hand. And now you're trying to get a warrant. And the officer says, I can't issue the warrant, but what I'll do is I'll refer you to the court. In many counties throughout the state, we have what's called magistrate court. Magistrate court deals with small charges. It deals with criminal warrant applications. It oftentimes deals with county ordinance violations in your respective county. It also deals with certain types of civil suits. Usually the threshold not threshold, but the max that they'll deal with is usually $15,000 or less. So to put you in the headspace of what this court is structured like, think of like the People's Court or Judge Judy or Judge Mathis. It's where people come with issues and that court deals with the smaller issues. So that officer doesn't want to issue the warrant. You could go down to this court, fill out an application, and say, I want an arrest warrant issued for this person for theft by taking felony because it's over $1,500. What that court will do is they will set down a court date. You and that person will come to court, and the judge will hear from both of you and decide whether or not it is appropriate for that person to be arrested on that charge. So, just to give you a summation, police officers can issue charges, but so can individual citizens through the court process. Next slide. So, in terms of your rights, I hear often people say, I had a Fifth Amendment right to remain silent. That officer did not read me my rights. Well, I want to warn you that the officer doesn't always have to read your rights. So if an officer comes up to you and just wants to speak to you, they can do that. They don't have to read your rights. An officer can come up, have a casual conversation with you, and you have the option of whether or not you want to participate in that conversation. So there is a Supreme Court case that talks about this. It's called Terry v. Ohio, and in that case it talks about different tiers of police-citizen contact. The first tier is basically, tier 1, where an officer can just say, hey, what's your name? What are you up to? And you can answer those questions or you can walk away. The second tier is reasonable suspicion. This means the officer can detain. What could be an example of this? Well, let's say the officer received a be on the lookout, a BOLO, for a person wearing a particular outfit, very specific, fitting or describing a certain description for this person, and the officer stops you under the premise that you match this description. Well, in that instance where it's a tier 2 encounter, the officer can approach you. The officer can ask you questions. You have the right to say, I don't want to answer any questions, but also understand that usually in a tier 2 stop, where an officer is telling you, you appear to look like a suspect, or the officer is asking questions under the premise that there's a BOLO or be on the lookout for somebody, you are not free to leave that encounter. The only way to leave that encounter is to ask. The third tier is probable cause. If there's probable cause, that means the officer can arrest you. So the first thing that has to be in effect in order for you to say, I have a right to Miranda, you have to read me my rights, you got to be under arrest. Now, arrest doesn't always mean you're put in handcuffs. Arrest means that you cannot leave on your own free will from that encounter with the officer. So you could be talking to the officer and you say, I just don't want to talk anymore, I want to leave. If the officer is like, well, you cannot leave, you have to submit and stand here until I tell you it's okay to leave. In that circumstance, the first component of Miranda is met. The second thing that has to happen is the officer has to ask you questions. If the officer is asking you questions after making it clear, either through what they tell you directly or through their mannerisms, like you can't get out of a patrol car, they put you in a patrol car. That could be a mannerism or something that lets you know, hey, I'm not free to leave this scene. I'm not free to leave this situation. In that circumstance, when that happens and the officer is trying to question you, that officer is supposed to read you your rights. If the officer arrests you and they're only asking you questions like, what is your name, what is your date of birth, what is your mailing address, those types of questions, those background questions don't warrant, he doesn't have to read Miranda. But if the officer is saying, well, where were you the night before last at 7 o'clock, and who can verify that in that circumstance where the officer is trying to obtain information about a crime, information that's not background information but sounds like he's investigating or she's investigating something, they do have to read you your rights. And so if you were in a situation where you're in cuffs, if you're in the back of a patrol car, if officers have you surrounded, the easiest way to know can I leave or not, is to ask the question. And I implore you that when you ask the question, be polite. Oftentimes, officers can be intimidating, especially when there's more than one of them. And then on top of that, some officers can take a very nasty tone with you. In those circumstances, I always advise, please keep your cool, keep your professionalism, be polite, because the name of the game is you want to survive the stop so you can tell the story. And it does not serve you to get into an argument, to curse out, to throw a tantrum, to resist, to fight the officer on the scene. You always lose when you're on the roadside fighting the officer. Where you win is in the courtroom, or where you win is through that internal affairs complaint process where you show that I've carried myself with dignity and with respect, and these officers were horribly disrespectful. So just keep that in mind. So to recap all of that, I just want to make it clear that when you're dealing with police, they don't have to read your rights unless you're under arrest and they're questioning you in a way that sounds like they're investigating a crime. Anything outside of background questions. And the second thing that I want to just remind you as a takeaway is that when it comes to your rights, in terms of the right to remain silent, the right to an attorney, the right to be free from unreasonable search and seizures, just keep in mind, keep your cool, be polite, do not get into it with the officer out there, let a lawyer get involved. And I do want to tell you all that typically most agencies, not all, but most agencies do have dash cam, and they also have body cam. And what's really great is oftentimes a police department or sheriff's office standard policies and procedures manual, you can usually find that online. I would check their local website. If they don't have it, you could do an open records request for it directly to that local department. But like here in Augusta, Richmond County, the policy states that when officers are having citizen encounters with members of the public, in other words, they're supposed to activate their body cam and they're supposed to preserve that information. And legally, you are entitled to that body cam footage as long as there is not like an imminent danger to release that at that moment in time. But inevitably, you can get that footage, whether it's through the district attorney's office, the solicitor's office, which are two prosecuting agencies in the state of Georgia, or directly from that law enforcement agency. One last thing I do want to hit on in terms of searches, because I know this comes up a lot. When can I say no to a search? Can an officer just search me without my consent? So to the question of when can an officer search you, to people who are on probation, you need to look at your sentence. In my county and in the neighboring counties, these judges put as a special condition of probation that they have to submit to searches. They sign Fourth Amendment waivers, or assign Fourth Amendment waivers in those cases, typically. So if you are on a sentence right now for parole or probation, typically what goes along with that is that you've signed off or you have agreed to waiving your Fourth Amendment rights. In other words, you gave up your right to say no to searches. When it comes to a citizen who is not on probation or parole any longer or just never have been, you always have the right to refuse a search. If an officer wants to pat you down, you can say very politely, I do not consent to this pat down. If they want to search your purse, your backpack, your car, your home, you can say, I do not consent. And at that point, the officer has to make the judgment call that do they have probable cause to search you anyway, or can they go and get a warrant to search you, or do they just drop it? Now, when it comes to searches, there are exceptions to your consent. So if, for instance, you refuse to consent to search, and that officer decides to search you anyway, one exception that the officer can use is to say it's for safety. Officers are going to be given a lot of leeway with the safety argument because oftentimes encounters between people and officers are stranger to stranger. And if that officer has concerns about you might have a weapon that could be used against them to potentially harm them, that officer could decide they just want to do a pat down. And that's simply what it is, a pat down. That does not give them permission to stick their hands in your pockets or to go through your purse or go through your center console in your car. But it does mean that if they want to do a pat down of just your person, they can do that. Now, if they feel in the pat down of your person what they believe to be the shape of a knife or the shape of a gun, in that circumstances, our courts have said in Georgia it's okay for them to remove it or have you remove it from your person. Now, in terms of the second exception, it could be an exigent circumstance. Exigent circumstance is a fancy way of saying there's an emergency, people's lives are in stake, I've got to go and do what I have to do. So the most common example would be, let's say the officer is chasing somebody on foot and the person runs into a house. Well, that officer ordinarily cannot just go into somebody's house looking for somebody. They need a search warrant. But in that circumstance, if a person has been involved in a crime and the officer is actively in pursuit of that person, that officer is going to be allowed to go into the house and try to find that person and pull them out, arrest them, and take them into custody. Another often common example would be, for instance, if the officers are at a house, they see drugs on a table, they see weapons and other types of contraband, they're not going to be forced to ignore what they see. Now, in the best case scenario, they detain everybody and they get a search warrant. But if that does not happen, officers are probably going to get permission, and by permission I mean by the courts, to go in that house and to seize that evidence. Because at that point they have probable cause, it's right there, and if they don't do something right then and there, that evidence could be destroyed. Now, I know that I talked some about when you have these contacts with law enforcement officers, the kind of questions that they can ask, like background questions. And what comes to mind is like ID. If someone has their ID on them and an officer is asking to see it, again, that is a situation where you can respectfully decline. If you don't want to give the officer anything, and this is a tier 1 encounter where the officer has no reason to suspect you of a crime, they're just out talking to you, they can ask for the questions. They can ask the question for the ID. They can ask, where are you going? What are you up to? They can ask these simple questions. But you, in that circumstance, have the right to say, officer, respectfully, I do not wish to submit to any questioning. Am I free to leave? I find typically if you know that you're not up to anything and nothing is wrong, nothing has happened, and you're not involved in anything, you don't have anything on you, and this officer is asking to see your ID, I might comply with that just because it'll end the encounter sooner. But if I have any concern that, oh boy, am I involved in something? I feel very uncomfortable. I don't like this. Then I would say, hey, officer, respectfully, I do not wish to have this interaction, or I don't wish to submit to questioning. Can I leave? And from there, the officer has to decide, are they going to escalate it? Because if they escalate it, that's a double-edged sword. It could lead to something really bad for that officer, meaning that you could have a basis to file a complaint that could potentially put in jeopardy their job. Or alternatively, it could lead to them finding something. But if they find something, don't resist it. In the sense, don't physically fight the officer. Continue to express that you do not consent if they're trying to search or they're trying to continuously ask you questions, so that if it does evolve into a court case, your attorney has something to argue. So I would go 2 slides forward. So in terms of what happens, just to kind of flesh out even more this arrest, the bond process, and I talked a little bit about arraignment, but what's happening in between those stages? Well, what happens in between the stages is that there's something called grand jury. Some of you may have heard of that before. Grand jury is basically a proceeding where 16 to 23 people in that county are hearing testimony from an officer or a victim or a witness of a crime. And they are deciding in a room, usually it's a courtroom, whether or not there is probable cause to bring formal charges against a person. So a person could be out on bond or in jail on an arrest warrant set of charges. And from there, you're thinking, well, why do we need an indictment process, or why do we need an accusation to be filed? Well, these are proceedings that our legislature has determined is the way that we're going to formalize the process. And so a grand juror has the authority to either collectively decide we're going to do an indictment because there's probable cause, meaning we're going to formally charge this person with these offenses, or they could do what's called a no bill. A no bill is a fancy way of saying we don't think there's probable cause for an indictment. We're not going to go forward with these charges. And if that's what happens, then that district attorney's office has to decide whether or not they want to try again with a different set of jurors for charges, or do they want to let the case go? Now, I can tell you that here locally where I'm at, if the grand jury does not indict, it's pretty much a foregone conclusion that the district attorney's office is just going to drop the case and let it be. Now, in terms of accusations is another way to formalize charges, but it doesn't require a grand jury. Usually you're going to see accusations with misdemeanors. With felonies, you got to have the grand jury. Now, in limited circumstances, the law has changed to allow for more charges to where you don't have to have a grand jury to decide, but particularly with your serious violent felonies. And when I talk about serious violent felonies, I'm talking about murder, aggravated sodomy or child molestation, armed robbery, certain levels of aggravated assault where it's involving a police officer, certain charges like that fall within the purview of serious violent felony, or like kidnapping, especially if the alleged victim is under 14. In those situations, you're going to have to present that before a grand jury. But if it's like simple possession of cocaine that's less than a gram, no, that doesn't have to have a grand jury to decide on that. That could be an accusation. Now, I see that there's questions about how long can a person sit in jail. It's going to vary by the county. It's going to vary by how fast your district attorney or solicitor general moves on cases. When you have a felony charge and you are in jail without bond because a judge has denied bond, typically the rule is 90 days. If after 90 days of being in jail, after having been denied bond, that person does not have a bond, after 90 days, you can file a petition with the court and ask for the bond, because bond has to be set regardless of what the prosecutor wants if it's been 90 days since that person's arrest and they have no bond. What could potentially make a person ineligible for bond could be, let's say, and it's by the judge. There's no hard, fast, in a hurry type of rule. But for certain judges, when they hear there's gun violence involved, they're less inclined to want to release that person onto bond. So there's a statute, I believe it's 1716-1, and that statute talks about what offenses are bondable before just a superior court judge. And to just explain what a superior court judge is, a superior court judge is the judge that hears felonies. They are the judge that hear divorces and domestic relation type cases like child custody, legitimation actions, child support actions. They are the judge that deals with lawsuits that exceed $15,000. They are the highest, in terms of the hierarchy of courts, they are the highest trial court level. So it's Superior Court, then it's Court of Appeals, and then there's Supreme Court. So Superior Court is the highest trial level for a case to be heard at, and that's usually where a felony starts. Bond factors in the statute that I referred to is what the judge is going to base their decision on, because statutorily they have to. So the bond factors are, is this person a flight risk? In other words, will this person, if I let them out into the community, are they going to try to leave and, for instance, go to a country with no extradition or leave the state to never be seen again and not show up for their court dates? The second bond factor is going to be, is this person a threat to the witnesses and the victims in this case? So if this is a case where it's like a theft or a shooting, where somebody got hurt or somebody was impacted, the court is going to want to know, well, how does that victim feel about this person getting a bond? And if that victim doesn't want the person to get a bond and the evidence seems pretty reliable that the person who's up for bond may have done it, judge might find that that's a reason to disqualify that person for bond. Another consideration is, if I let this person out on bond, are they at risk to commit further or additional crimes? So if I let this person out on bond, from the judge's perspective, is this person going to go out and get arrested again for another crime? But this time, the crime is more severe, or just the fact that they got arrested for another crime when, as a condition of bond, you're to violate no laws. And then the last consideration that the judge takes into account statutorily is, if I let this person out, are they a threat to the community in terms of persons and property at large? Is this person a threat to my neighbor, or a threat to the people in this courtroom, or a threat to others in the community? And so if the judge can answer yes to any of those questions, that's going to make the person ineligible for bond. Now, once we do an indictment or an accusation on a charge, and if I can go to the next slide, you're going to have a situation where things are escalating very quickly. Court dates are going to be more frequent. In addition to that, you're going to have instances where you're going to have to make decisions on how to proceed. Well, who helps, or how do you make these decisions? My recommendation always is going to be, involve a lawyer. Please. The moment that you have an inkling in your spirit, in your gut, that a storm is a brewing, that a charge is coming down the pipeline because a police officer has called you or called your family member, and they start asking questions, and those questions make you feel uncomfortable, they make you feel like you're a suspect, that's when you need to get a lawyer involved. So let's just say, for instance, you're not in a position to afford a lawyer. Our Georgia and federal constitution provides that if you cannot afford a lawyer, one will be appointed to you. They are called public defenders. Now, I realize that there has been an overall nationwide consensus or perception of public defenders that they're not lawyers, or they're not as good in lawyering as other lawyers. I can tell you, as a former public defenders work very hard, and an experience is individual, not collective. So everybody has, when they're talking about public defenders, they have their opinions, and those opinions are based off of real experience for them individually. But what I encourage is that if you are aware, or you personally had an experience with a public defender that was not positive, I encourage you to just charge it to that person and not to the whole establishment. Because, to just dispel some myths, public defenders do not get extra benefits if they work against their client. They do not get paid more. They do not get more time off. They do not get rewarded for that. Public defenders oftentimes are people who just have a heart and a passion for helping those who do not have the means to hire their own lawyers. And I have to tell you, public defenders take a serious pay cut when they take that type of job. As someone who worked there, here locally in my community for 6.5 years, I can tell you my earning potential was significantly diminished by being a public defender. It wasn't until I stepped out on my own that I tripled my pay. But I say that to say that, give them an opportunity to demonstrate their work ethic before we make snap decisions about the kind of person, character, and attorney that that individual is. Because oftentimes you will find there are quite a few public defenders that care for their clients and care about what happens in our fighting. Private attorneys, on the other hand, we are attorneys who are paid money. And a lot of times, I will tell you that, especially in felony representation, it's not inexpensive. And so, if you are in a position to hire an attorney, or if you are in a position where you have to hire a private attorney because you do not meet the qualifications for a public defender, what's going to be important in deciding who represents you is, do you feel like you can trust this person? Because when you're being represented by someone, it is a relationship. And it is a relationship that's going to be based on trust. And trust also requires total transparency and honesty. The more honest you are about your situation, the better it positions your lawyer to be able to represent you to the best of their ability. Giving them half the story only sets them up for failure. And then, in terms of when you talk about representation and the caliber of representation, just keep in mind that it's not just on the lawyer to make sure the case is progressing in the right way and that you are informed. You too have a duty and responsibility to stay on top of it. So, I from time to time have heard people say to their lawyers, well, I hadn't heard from you. After we, had this court date, I hadn't heard from you. It goes both ways. Like, you have to be your advocate in addition to your lawyer, whether it's one that you hired or one that you are appointed. You have to also put in the effort. You get what you put in, because this is your livelihood, not theirs. And whatever happens in the end won't impact the lawyer, it impacts you. So it's important that it's a team effort, that it's an effort that is built on transparency and trust, whoever it is that you have represent you. And that, in my opinion, is a solid recipe for success in your case or getting the best possible outcome. Next slide. So when you are meeting with your lawyer in the process of this case, the big things that you want to make sure you stay on top of and asking is, hey, were my rights, let me tell you what happened. Here's the full story, the good, the bad, the ugly. Were my rights violated in any way? If your rights weren't violated, then that eliminates a motion. Now, if for some reason, there is an issue, your lawyer is best positioned to put together the appropriate paperwork to challenge any evidence that they believe may be used against you in court. My thought is, whenever something is happening on a case with a client, what I typically do, at every stage they are informed. My office does reach out to the client. We send them letters, we send emails, we send text messages. And we say, hey, we need you to check your email and we need you to get back to us after you've read it. I encourage appointments because we always want to stay on top of what is it that we're seeing, what is it that we're getting, and what is it that we need to do in order to ensure that the best outcome is. Now, I'm going to tell you that some people may not like this approach, but this is my approach. I am extremely direct with clients. If you are charged with armed robbery, which is a serious violent felony under Georgia law, I'm not going to sugarcoat and tell you that that's a probation case, because it's not. Armed robbery carries a statutory minimum of 10 years in prison without parole. I'm going to tell you that. And so what we have to figure out is, can they prove the armed robbery? If they can't prove it, but they can prove something, can we get them to come down to what that something is, as opposed to you accepting a charge that is a serious violent felony and is going to have serious consequences directly and collaterally. I also recommend that when you get discovery, which is the state's case file, it contains the police reports, it contains the body cam footage, it contains every witness statement, it contains every piece of evidence that they believe establishes their case beyond a reasonable doubt. Don't just rely on your attorney to read that. You need to read every single thing that comes your way, period. The second thing I would say on that point is that when it comes to a case, do not talk to everybody about it. In fact, talk to nobody but your lawyer. And maybe your parents or someone that is very trusted and near and dear to you. I'm not sure if you're aware of this because it doesn't happen often. But let's just say hypothetically, you've got a best friend that you talk to very openly about what is going on in your case. And you tell them something that is harmful to your not guilty plea. Well, if it comes to the knowledge of the prosecutor that you're having these conversations with the best friend, that prosecutor could subpoena the best friend to your court dates or to your trial and use what they say against you. They can talk about what you told them. And that person, whether they want to come or not, through a subpoena, could still be compelled to talk about what you admitted to them. So be very careful about what information you share with others, because even the closest people to you might betray your confidence and talk about what you told them in the strictest, most upright confidence. So don't do it, is my advice. I would also say that when it comes to attorney-client privilege, my practice is I'll talk for certain with my client, but when it comes to talking to the mom, the mother of your children, your cousin, your other girlfriend, your employer, all of these other parties, I'm not going to do it. I'm just not going to do it. I'm not going to tell everybody what's going on with your case. If there's one person that you trust, absolutely, I would recommend, as opposed to you telling them what's going on, you let the lawyer tell them what's going on. Because we can filter what is stuff that needs to stay between us and what is stuff we can tell them to where they feel informed. So be very careful, I hope is the takeaway you're taking from what I'm saying to you right now about who you discuss your case with. Because attorney-client privilege is between the attorney and the client, and the only person who could say, I give up the privilege of confidentiality is the client. Okay, next slide. Okay, so the district attorney's office, because I've talked about this in passing, but let me just flesh that out a little bit more. I know a lot of people think that the most powerful person in the courtroom is the judge, but truth be told, I believe the most powerful person in the courtroom is the DA. And let me tell you why. Because the DA decides whether or not a police officer has a case to present to grand jury or to file an accusation on. The DA decides whether or not a person should be prosecuted. So whether or not there's a charge ever brought whatsoever, a DA gets to make that call. The DA has the ability to reduce a charge. DA has the ability to dismiss a charge. The DA has the ability to divert the case from a judge and put it into a diversion program that would potentially result in some kind of punishment. But if the person successfully completes the punishment, the charge is dismissed and eligible for record restriction. Record restriction is a fancy way of saying expungement. Prosecutor can decide whether or not, a case that was convicted and sentenced, whether or not that person's entitled to record restriction or first offender or conditional discharge. Prosecutor can decide, if a person is in fact guilty of a charge, what should that sentence be? Prosecutor can also sway a judge and say, well, judge, we're comfortable with probation, or we're comfortable with time served. A lot of times, a judge is going to go with what the prosecutor is asking for. Not always, but a lot of times. And so, a prosecutor is a very, very powerful person when it comes to what happens in the course of the case. Now, please don't make a mistake in thinking that the prosecutor can do all of that on their own, because ultimately, the person who has the final say-so on whether or not what the prosecutor wants to do is acceptable and legal, that's going to be the judge. The judge makes the final decision of whether or not they want to honor that dismissal or honor that recommendation or honor that diversion program. But the prosecutor sets all of that into motion, or it can stop everything from progressing in motion. Next slide. So at an arraignment, again, that's just not guilty or guilty to the charges as indicted. Typically, it's just the prosecutor, the judge, the clerk of court, and the defense attorney and the person who's accused at that court appearance. The judge has the option to read to you the charges, but oftentimes, before you even go to that court date, you know what you're charged with. I do want to talk about, though, the rare occasion that a grand jury arrest warrant happens. A grand jury arrest warrant is when a person was not arrested. A person is not even likely aware that they're under investigation for charges, or if they are aware that they're under investigation for charges, an officer doesn't come back and say, we're going to arrest you for the charges. What typically happens is the person receives a court date in the mail. Person's like, well, why do I have a court date? I don't have anything outstanding, and I've never been charged of anything. And when that person goes to court, they have the misfortune of being told at that time that a grand jury heard a case and determined that they should be charged. And then that person is charged, and in court, they are arrested. So in that situation, that could potentially happen at an arraignment. But again, that is why having an attorney is so very important. Because by having an attorney, that attorney can look up through the court's records, which again is public record, and figure out if there's a grand jury arrest warrant or not, or get to the bottom of why there may be charges, or why this person might have received a court date in the mail but had never been arrested. Next slide. So, next slide. Following arraignment, just to fill this in, again, you've got your docket call, your calendar call, you have pretrial conferences, and ultimately you got to make the decision, am I going to trial or am I going to be sentenced? Well, let's just say you decide to be sentenced. On this slide, it identifies ways that you could be impacted by pleading guilty to a felony. Now, let me tell you, most times misdemeanors are not going to have severe collateral consequences unless it's like a traffic ticket. Certain types of traffic tickets, like DUI, leaving the scene of an accident, if you get more than 15 points in a 24-month period, those types of offenses will suspend your driver's license. If you get a fleeing from police, that'll suspend your driver's license. So there are certain offenses that on a misdemeanor level will suspend your driver's license. Another thing to keep in mind is if you are convicted, meaning you pled guilty or you are found guilty at trial of domestic violence, anything. So that could be a simple assault, a simple battery, a cruelty to children, misdemeanor, third degree, a terroristic threat, anything that has the acronym FV at the end, family violence. If you are convicted of that, federally, you're going to be prohibited from having a gun. That's right. So you could be somebody who just got convicted and sentenced on a misdemeanor, domestic violence charge, but there is federal law that says you cannot have a gun. So before you consider pleading guilty to a charge like that because you just want to get out of jail, or things got heated and it was a push, or it was a flick with your finger, or a point, and you just want to take responsibility and be done with it, just understand what is going to be the consequence of that misdemeanor. Now, with felonies, if you are a convicted felon, you lose the right to have a gun. You lose certain privileges when it comes to employment. Employers typically can take into account your background. In fact, they're going to ask about your background. And I talked extensively about questions and how they're changing on your applications. So I won't reiterate that. But in terms of when you are applying for the job, I find you got to be straightforward about it. And if there's a way before you are sentenced to avoid a felony conviction, your attorney needs to help you figure that out. The two primary ways of avoiding a felony conviction is going to be first offender and conditional discharge. Both of them act as a way to essentially save your record from a conviction. And if upon successful completion of the sentence, you're able to have it sealed so that employers don't see it on your background check. Now, in terms of like, let's say you are a convicted felon, you lost your right to a gun in Georgia. There is a right to get your gun rights back. And in fact, I've been very successful in getting that done several times. What happens is if you go on the Georgia Department of Pardons and Parole page, they have an application online. It is electronic. You do it from your computer or from the computer at the library or wherever you can access a computer. It is very thorough. They're going to ask questions about, are you married? Do you have kids? Are you on child support for these kids? Have you ever been sued civilly? What is your criminal record? They're going to ask you, talk to me about what happened. How did you lose your rights? What was the underlying charge? From your point of view, tell me about that charge. Tell me what you've learned from that charge. They're going to want to know all your employers since the date of your conviction. They're going to want to know your level of education. They're going to want you to pull your records from school, like your transcript, or proof that you graduated from that technical college or that college or from that program. So it is a very rigorous, thorough application process. And you're also going to have to present character letters. Usually they want 3 character letters from people who are not related to you by blood or marriage. They want those letters to be from reputable people in the community who could talk about how they know you and why you deserve your firearm rights back. And in addition to that, you're going to have to get an up-to-date background check, and they may ask for supplemental records like pay stubs or W-2s. And so, yeah, it's a very evasive process. It's not quick. Usually the Georgia Department of Pardon and Parole, they ask you to give them 9 to 12 months to process your application. But what I have noticed, especially within the last year, is they've gotten much quicker about it. I've seen a turnaround time around 3 to 4 months in getting back to the applicant on whether or not they're going to approve it. In certain instances, they may want an interview. So they may tell you to come to a certain location and they'll meet with you and they just have questions about your application and about you and what it is that you, what is the reason that you want your firearms restored. So absolutely, you can get your gun rights back. In terms of voting, please, you can vote. Please vote. As long as you're completed with your sentence. That is the rule in Georgia. There are some states, like I know Mississippi, Alabama, you lose your right to vote indefinitely. But in Georgia, what happens is, yes, while you're incarcerated or yes, while you're on probation, you lose your right to vote. But the moment that that sentence is completely over, you can re-register to vote and you can vote, okay? So make sure that if you have a situation where you are a convicted felon and you want to vote and you're done with your sentence, register in your county where you live and get to it. Vote, vote, vote. In terms of housing, education, there are some restrictions on convicted felons. It's my understanding, though, that there's time limits on that. It's just so key that anytime you are charged, you really want to explore every pathway before you just enter a guilty plea to a straight up felony. The other thing that I want to mention is that sometimes it happens where you've been convicted of a crime and you were first offender eligible and you didn't know about first offender. Maybe you weren't represented by a lawyer or your lawyer never went over it with you so that you could definitively make an informed decision. There's something called retroactive first offender. If you don't have anything else on your record, it was just that charge or it's the only felony on your record and you want to use your first offender and you just didn't know that you could, you can apply through the court system to have that judge make a decision as to whether or not you should get first offender. And what happens is it backdates to where your sentence is treated, if granted this request, as if you did receive first offender, which means that immediately the charge is sealed. So I've had a great deal of success with that. It's a great feeling when you've had this conviction and all of a sudden you can have that conviction sealed because it turned out you were eligible for first offender. Another thing with misdemeanors, there's something called second chance. So there are district attorneys' offices across the state that have second chance desks. And what this is certain misdemeanors qualify for record restriction. Now, some misdemeanors are not going to qualify. Like a DUI is not going to qualify. Domestic violence, that's not going to qualify. But think about like maybe a shoplifting, certain traffic charges, you can apply to have those charges restricted. You file a petition with the court, or you can go to your sheriff's office or police department. And I know here they have an application, and you can individually complete that application and turn it in. There is a fee associated with the processing. It can't be more than $50. And then that agency sends over the request to the prosecuting office, and that office consents or objects to whether or not that gets approved for restriction or expungement. And if it's approved, it's sealed on your record. But if it's not approved, you can appeal it to the court and see if the court would grant your request to have it restricted or sealed off. Next slide. So I just want to recap on everything, because I know I've given like a ton of information and there may be an information overload that's happening. Our judicial process works with, you got the arrest, you got bail bond, you've got arraignment, you have docket or calendar calls, you have trial or sentencing. And depending if you are not able to get your charges dismissed or you're not acquitted at jury trial, then from there, what you have is a sentence. And if it's a felony or certain misdemeanors, there are going to be consequences, maybe to your driver's license, maybe to your ability to get that job or to go into that program at the school or to participate in certain activities. You can vote as long as your sentence is complete. If it's a felony situation, if it's a misdemeanor situation, your right to vote is not jeopardized. And in terms of, record restriction, restoration of rights, you can apply for that through, if it's, you're trying to get your gun rights back because you're a convicted felon, or you're trying to get a pardon because you're a convicted felon, you'll go to the Georgia Department of Pardons and Parole website and complete their electronic application. If you are a felon who wants a pardon, or you're a misdemeanor person who wants a pardon, it's the same agency, it's the same application. If you are someone who wants to get record restriction, meaning you've got some misdemeanors and you want to see if you can get them off your record, there's an application. You can go to your local sheriff's office or police department to try to get that application. There's also a program called the Second Chance Desk, and that is usually offered through a district attorney's office. Not every district attorney's office has it, but there are select district attorneys, usually in counties that are Democratic, if you know what I mean, that have those programs that are available. A great resource for record restriction and expungement is the Georgia Justice Project. They are based in Atlanta. They, I believe, have forms on their website where you can, it's like a petition. I think they have a simple petition in order. And I think that they have some literature on how you can do the process yourself. And in limited circumstances, they'll help you with the process if you call and maybe schedule some time to talk to somebody. And so just at every step of the way, when you are in any way, shape, or form, you, a loved one, someone you know is involved in the legal process, as all of these things are happening, the number one thing you've got to do at the outset is involve a lawyer, because a lawyer is going to be able to very proactively and meaningfully help the situation and figure out how to get the best possible outcome for that particular person. So at this time, I've talked a lot. You all tell me what questions you may have, and I'll see how I can answer that for you. And just want to say again, thank you for Bard Business. to Ms. Boyd and Ms. Calhoun for the invitation to speak this evening. And thank you all for just participating tonight and giving me your undivided attention about your rights and the things that go on at various stages of the legal process. And I see a comment about the term felon is dehumanizing, and I agree. I do not like that label. I will say this, unfortunately, that term is a legal term, and it is a term that is heavily intertwined with our law. And so when I speak of using that word, I'm using legal terms of art that are used by our court system. And so, please, speaking for myself, know that I mean no disrespect in using that word. And the language and the terminology that I'm using is the terminology that you're going to find in the statute and that you're going to find is heavily used in the court system to describe different processes. So I just wanted to ask, did anybody have a question?
So there are a few questions that are in the chat.
Okay.
I'm going to go ahead and let's get a few of them. You did answer quite a lot. Kenneth Williams said, what makes you ineligible for bond?
Okay. So with respect to bond, it goes back to those factors. Flight risk. Is that person going to leave? Are we going to see him again for future court dates? Is that person a threat to the witnesses or the victim? Are they going to obstruct justice and try to influence people? Like, I think about the Diddy trial, right? You think about how everyone was very concerned that he was a flight risk because he's a billionaire. And they were concerned that he was intimidating witnesses because people were coming forward and saying that they were receiving calls from him directly, discouraging them from cooperating with the U.S. Attorney's Office. So those are examples of factors. Also, when you talk about, is that person a threat to the community at large or property? And lastly, if that person is released onto bond, are they likely to commit future further crimes, whether misdemeanor or felony? So those are things that are, if the judge answers yes to any of that, then that's going to, in a judge's mind, say that person is ineligible for bond. Another thing to think about, too, is the situation where a person could already be on probation and then they get arrested on a new charge and they're asking for bond on that new charge. If a person is typically on felony probation, sometimes misdemeanor too, probation is going to place a hold on that person. So even if they get bond, they still can't get released. Or a judge, a lot of times, will use the fact that a person has a probation hold to say that disqualifies you from bond, because even if I give you bond, you're not going anywhere because you're already on a sentence.
Wonderful. I do want to say how our folks are really engaged tonight. So we are going to take a few more questions if you have time, if that's okay with you, Attorney Nash.
Yeah.
Okay, good. All right, so we have a gentleman who is asking, can we talk about body cam evidence? How do we utilize body cam evidence?
So I love body cam evidence because typically the camera doesn't lie. The good, the bad, the ugly, it's going to show it. And the officers don't have the access to be able to manipulate it. It's like a third-party agency, at least here, that handles the cloud for that footage, where that footage is uploaded. And it's going to be extraordinarily suspicious if footage disappears, because in certain counties, especially in urbanized areas, cities, there's going to be body cam, because that cements trust between the public and law enforcement. Now, the way that it can be used is, let's just talk about something simple like a traffic stop. And let's say the traffic stop escalates to a DUI arrest and a drug arrest. Well, with the body cam, what that does is it allows an attorney, prosecutor, and a judge, and a jury at some point, if you decide to go to trial before a jury, to review that footage and see step by step, how did we get to the point of an arrest? What did the officer say? What did this person say? In response to what the officer said, and vice versa. When the person performed the sobriety test for the DUI, I mean, how did they do? Did they do really well? I mean, mistakes are expected because, I mean, it's not like we walk around knowing how to do a DUI test. And so, I mean, if it's the first time you're doing one, you're not expected to be perfect. And so, in that circumstance, is that person, you know, do they appear to be impaired to the point that they can't drive? And then, what about these drugs and this gun that we found? I mean, did that person actually consent, like the report says that they did? Or did the officer just bypass them, not even ask them if they consent to search, and went into that vehicle and went searching anyway? So body cam footage is extremely helpful because it's supposed to be an accurate depiction of what exactly happened. Everybody has their perception in that moment of what they experienced, and sometimes that perception matches what is actual factual, and then sometimes it's not all the way actual factual. Sometimes it's a little different, but you know, typically body cam evidence can help either build your case very strongly, or it can hurt your case, or it could have a neutral effect where it showed things on both sides. And usually for me, the way that I would use body cam in a case is if I'm going to do a motion to suppress evidence, I'm going to use that body cam footage to help make my arguments. And if I'm using, or if I'm going to trial and there are things that I think are just outright egregious, or further support my client's statement of what happened, I'm going to present that to a judge or a jury at the trial. So, body cam footage is a great thing, it is a great tool. And sometimes, if the body cam footage is really bad for the client, meaning the client just had a completely different recollection of what happened, and there's nothing to indicate that that video has been compromised in any way, it helps in talking to the client and saying, so this is what happened. Do you remember this? And it refreshes the client's recollection because sometimes, like I said, cases could linger for years. And you might have in your memory fresh what happened the day after, but 4 years down the line or 2 years down the line, heck, 6 months down the line, your memory starts to change or it starts to evolve into something different. So those videos are so instrumental and for everybody and just refreshing recollection, building a defense, or being clear on we don't need to fight this any longer. We need to try to figure out a pathway to a good outcome.
Wow. This has been some just incredible, phenomenal, awesome information. And we are just so thankful for everyone who has joined us tonight, but especially our guest speaker, Miss Attorney Catrell Nash. It has just been a heartfelt, um, this has been just a heartfelt movement for all of us who are so passionate here in this work. So we just thank you so much for just the phenomenal knowledge that you have brought, your wisdom, your clarity, and just your dedication to helping us just to empower, our folks. It's just, it is deeply, deeply appreciated. And on behalf of our business, we want to just give an extended heartfelt thank you to each and every one who showed up here tonight. You didn't show up for yourself, but you showed up for your community. And this is really, critical conversations, hard conversations, challenging conversations, but you made the time. You made the time to be here and you made the time to empower yourself. So we thank you for that. But before we go, we also want to invite you to join us again for our Know Your Right series. We will be back on August 21st. August
Okay.
21st from 5 to 7. And Miss Nash, we definitely invite you to come back with us and join. We will have our session again, so we'll be here together. We want to make sure that we stay connected, we stay empowered, and we always just want to make sure that we are empowering our folks so that not only again for yourself, but so that you can share it with your neighbors and your loved ones. So, do you have any final words for us, Miss Nash?
I just really want to again just thank you all for putting this on. I think this is such just necessary work. It's so powerful to everybody who joined tonight to just absorb the information, I commend you as well, because knowing all the ins and outs, it's such a complicated process. And there are so many things that you may not even know unless you just sit and you listen or you research it. And sometimes you don't even know what you're researching. So taking this extra step to try to educate yourself and understand these processes and understand all of these different exceptions and how things typically work, I just hope that everyone took away something that maybe they did not know before. And again, I just want to thank you all for inviting me to just share some of my experiences and share what I know about all of this, having done it for almost 16 years, because this is, it's a very tough system. It is designed against us. And it's so important that we all have to be proactive together. And organizations such as yours are so needed and so important to ensuring that people are getting fairness and truly experiencing justice. Justice isn't just for one side, justice is for everyone. Justice is only served when you do right by everybody in the process. Otherwise, it fails. So just thank you, and thank you all for just giving me your attention and your awesome questions. Very thoughtful, and I'm just very appreciative. And just keep up the great work. And all of you keep up the great work.
Thank you again. So you heard it right there from Attorney Cottrell Nash. When we understand the system, we are better prepared to protect ourselves and push for the change that we deserve, because we deserve that change. So again, thank you all for coming out. We will be back again on August 21st. August 21st from 5 to 7, we will continue with our Know Your Rights so that we can be empowered and we can make the change that we so deserve. Thank you all. Thank you so much. Stay empowered and have a good night. We'll see you next time.
Good night, everybody.
Good night.